Hi, I'm Sylvia Mayer, arbitrator, mediator, and attorney located in Houston, Texas, serving as neutral for disputes all around the country. Thanks for joining me today for Mayer on mediation and arbitration. This is the fifth in the Breaking Up is Hard to Do 9-part series on dispute resolution for business divorces. When interpersonal relationships sour amongst co-owners, often the gloves come off and aggressive tactics become prevalent. In arbitration, this may take the form of a party engaging in constant motion practice, abusive discovery requests, obstructing discovery compliance, or delaying simply for the sake of delay. In mediation, aggressive tactics often include bullying, stonewalling, weaponizing time, and deputizing someone with inadequate authority. As a party, you can take steps to mitigate these challenges. First, know the applicable procedural rules. In some instances, the rules provide guidance or specify relief for these types of situations. Second, focus on the problem and not the person when considering your options and if seeking intervention. Third, keep your eyes on the prize, the ultimate outcome, and don't get drawn into time-consuming and expensive skirmishes. Fourth, instead of fighting fire with fire, find the areas of agreement. Nothing deflates an antagonist faster than agreeing with them. Find the common ground and build on that. As a neutral, whether mediator or arbitrator, our job is to establish guardrails. On the roadway, guardrails are designed to protect motorists from straying into dangerous territory. Similarly, in dispute resolution, guardrails are intended to safeguard the process leading to resolution. Arbitrators use a variety of guardrails to keep an arbitration on track. For example, discovery costs are often the biggest expense in litigation and, in some cases, ripe for abuse. Arbitrators may establish strict discovery schedules narrowly tailored for the needs of that specific dispute. Similarly, motion practice may be limited, or a briefing and hearing schedule may be established early on to address preliminary issues, discovery, and other pre-hearing disputes. At the preliminary scheduling conference, most arbitrators set the final hearing date and provide that it can only be changed upon good cause shown. While each of these tools is useful in many arbitrations, they may be particularly helpful to establish guardrails in a gloves are off type litigation. Mediators also use guardrails to keep the mediation process on track. Active listening and empathy are used by mediators to help parties process their emotions without derailing the process. Listening sessions can be used when a party comes in hot to mediation. A listening session is when the mediator meets separately with each of the parties, simply to hear their side of the story, to let them share and talk in a setting that is controlled and just them, and where we're not focused on offers or the sharing of information. It's just an opportunity to listen and let people get things off their chest. Reframing is often used to help a party pivot from provocative or incendiary commentary to more productive dialogue. And technology can be used to address inadequate authority. Whether mediation or arbitration, parties in a business divorce may start out ready to fire away, but a skilled neutral can implement various guardrails to safeguard the process leading to resolution. Thanks for joining me today. Please connect with me on LinkedIn or subscribe to my YouTube channel.